We are invited that this is the process of selection will be done. Now we find in the rules you have made such a provision which makes us almost impossible to contest. No level playing field. In that background, this violation of the rule is challenged, and if your lordship is with us, then one chapter is closed. They have to do afresh. And if your lordship do not agree that this rule is not ultra vires, then my submission is that even the application of rules is made in such a manner to give illegal benefit in violation of that rules. These are the 2 points. Now, so far the violation of the rules is concerned, my lord, may I just take your lordship, my lord, to the authorities. রাখো আমি একটা করে দেখাই ছটপট না করে I take your lordship statement to the latest judgment of the Supreme Court in Assam versus Rava 2025 volume 7 SSC 705. The judgment delivered by Justice Dipankar Datte. এখানে আরে এটা তো অন্যটা 25/7 SSC দেখা আছে এই তিনটে 18 নম্বর সিরিয়াল নাম্বার আমার বই দাও আমার বইটা কোথায় serial number. What are all these? These are judgments. Judgment compilation. Serial number 18. Serial number 8. 18. 18. 18. What happened? 529 to 550. 529 to 552. Judgment is. এই একটা কম্পাইলেশন দিতেও নয় ইন্দ্রাকে Give the first pages only, the references. You are not required to give the history of judgments. State of Assam versus Aravind Rava 2025-7 Supreme Court cases, page 705. ইন্ডেক্সটা দিয়ে দিলেও আমরা ফলো করতে পারবো ইন্ডেক্সটা হ্যাঁ ইন্ডেক্সটা দিয়ে দিচ্ছি Now, the relevant paragraphs would be, kindly will not turn to paragraph 39. That the issue was whether in absence of statutory rules, by administrative order, appointments could be done. The Supreme Court was considering, yes. Page 39. Paragraph 39. Yes, paragraph 39. It cannot be gainsaid that the factors of when, which, what, who, and how that are associated with the recruitment or selection process is the prerogative of the recruiting authority and the selectors. However, at the same time, the process has to be conducted consistent with the statutory provisions governing the same, if any, as well as principles of absolute fairness and complete non-arbitrariness. Though it is true that law does not postulate a fetter on the authority of the employer, state, and is within the domain of the government when to initiate a process of recruitment for public employment, either according to recruitment rules or even in absence thereof, it is for the government of the day to decide in which manner it proposes to conduct selection. What would be the various stages the candidate aspiring for appointment have to pass through in order to be placed in the select list? Who would be selectors and how weightage is to be given to each of the testing methods? A great deal of credence is lent to a process if it is fairly and transparently conducted in accordance with rules. Whatever be its source, without the slightest hint of any bias or favoritism or nepotism. Normally, it is not for the courts to interfere unless the process smacks of malafidis, that I have already tried to develop this point. However, the right to be considered for public employment being a fundamental right, it would be safe and prudent to have a recruitment rules to govern the process of selection so that the best possible talent is appointed in public service. Obviously, assessing the merit of the candidate aspiring for public employment on the basis of a prescribed standard would not only provide a level playing field for each of them, the excellence of an institution to which the appointment is made would depend directly on the proficiency of its number staff, and that would in turn depend on the quality and merit of those who offer themselves for selections and ultimately get selected, necessitating the selection to be conducted within a hidden taint or masked malafidis. Last but not the least, having regard to present times when corruption has been held to be a work of life by certain responsible citizens of the country, it would have been desirable if the process of recruitment of 104 constables were conducted after framing recruitment rules and also prescribing a written examination to keep the process absolutely above board. What is the principle is there must be a level playing field. And you have destroyed everything with a malafide intention. I have said, Lord, the malafide intention is not at all personal malafide, but malice in law is also malafide. This is the latest judgment, and another judgment will have to show whether any preference can be given at the time of initial recruitment, 1995 supplementary to SSC. Supplementary to SSC, page 235. Entry 70. राहुल पाटिल शिक्षण hey, daughter के reference to we'll all learn more law. आगे जॉर्ज साहब के दाओ वो दे पढ़ रहे gives us opportunity to learn the subject. Well, this is three judges bench order 1995 supplementary to SSC. Got it. Thank you, my. Got it. Yes. Kindly turn to the paragraph. Stated paragraph 13. Let me start from paragraph 11. We shall now briefly refer to the main grievances voiced by the learned counsel for the respective parties in connection with these two GOs. It was submitted by learned counsel appearing for non-Telugu speaking candidates that when a direct recruitment is appointed to any public service, maybe in the lower echelon of service, like Group T and Group 4 post, which may consist of clerical post, merit should be the criteria which the Public Service Commission should follow. If a candidate satisfied the basic requirement of eligibility for competing in such public recruitment, provision of such weightage of 5% of marks to Telugu medium candidates will only per se be arbitrary and discriminatory, and would be destructive of the concept of selection on pure merits. That even if Telugu be the official language as adopted by the state in the light of linguistic policy, once a candidate is recruited from the open market as per the relevant rules, before he is confirmed in service and before he is entitled to earn an increment in service, he is required to pass the Telugu language examination. This completely meets the requirement of the department that the candidate must be having working knowledge of Telugu to enable him to converse and correspond in Telugu with members of the public as well as the other government departments. This satisfies the object of securing efficiency administration. To put a further fetter at the entry point, But this is vital. By giving a special weightage of 5% marks on the aggregate to candidates who have passed their graduation examination in Telugu medium would therefore have no real nexus to the object sought to be achieved and would be counterproductive, as more meritorious students, even though having secured more marks in the aggregate in the competitive test, would be elbowed out by those standing far behind in the queue only on the specious plea that they have passed the qualifying examination in Telugu medium. But here the fact is so glaring. The fresh candidates even secured 100% marks on merit were out of competition because of 10 marks. And even these candidates who have passed qualifying graduate examination in English medium or any other medium in the state have to appear compulsorily in one of the paper of Telugu language. Therefore, he is also having sufficient working knowledge of Telugu to enable him to correspond in Telugu as required by the exigency of service. That when under the relevant recruitment rules for the post concerned, the minimum educational qualification prescribed is passing of graduation in any subject. The further question whether he has passed this examination in Telugu medium or English medium would be totally irrelevant. That if a candidate who has passed graduation examination in English medium cannot be told of the gets and can legally compete in the examination for recruitment to the public post advertised by the Public Service Commission, such imposition of 5% weightage of total marks in favor of candidates who had passed qualifying examination of graduation in Telugu medium would amount to imposing an additional qualification or eligibility criteria which is dehors the recruitment rules and would result in total arbitrariness and would amount to give a discriminatory and hostile treatment to all candidates who otherwise are qualified to contest but did not have Telugu medium at their graduation level. If I may put my facts here, language would be that the persons who are otherwise qualified to contest but did not have teaching experience will be out of consideration. It was also submitted that the object about maintaining the efficiency of the administration can also be achieved